Hi, my name is Clay Krebs. I'm a partner at Tonkon Torp LLP and a member of our Labor and Employment Practice Group. As our community prepares to reopen and get back to work, we want you to know we're here to help you. Our labor and employment attorneys are keeping up to date on the latest legal developments and are prepared to offer counsel, give advice, make online presentations, share written materials, or any other resources you and your business might need. Please don't hesitate to reach out to us. Click the link below to be connected to a Tonkon attorney. Take care and be safe.
Hello, everyone. My name is Kristin Bremer and I'm a partner in the Labor and Employment Department at Tonkon Torp. I am joined today by my colleague and the newest member of our Labor and Employment team, Chris Morehead. Good to see you, Chris. Welcome to our coffee break webinar, Managing Thorny COVID-19 Leave Issues. We've designed our coffee break webinars to provide you with practical advice for your business to thrive during this pandemic. Next week, you'll hear from Haley Morrison and Bob Carey, and they'll be discussing ADA issues related to COVID-19. And the following Thursday, you'll hear from Clay Krebs and Megan Ruther again, and they will be discussing what the future holds for telecommuting as the new normal and the best practices and policies there. Let me pause and make a note about this format. First, please know we are recording this webinar. You do not need to sign a disclosure and no private information of yours will be shared. Please know, however, that should you choose to participate in our Q&A section, your questions may be recorded in association with your name. We have designed this webinar to include many of the questions about COVID-19 related leave that we've received over the past 2 months. So hopefully we have anticipated and will answer many of your questions. If not, feel free to submit questions in the Q&A section of your Zoom app. After our presentation, we will conclude with a Q&A session and we'll try to hit as many questions as we can. Because the situation is rapidly changing, oh my goodness, it's been fast and furious and we've been all drinking from a fire hose. We may not know the answer or the question may be too nuanced or specific for us to address in this webinar. And we welcome you to reach out to one of us or the Tonkon Torp attorney that you usually work with. Also, we welcome any feedback you may have about this webinar. If there are topics that you want to hear about, tell us about it. We hope to be a source of information for our business community throughout this challenging time and plan to hold additional webinars going forward. Finally, information presented here as of May 14th, 2020 is not intended to be legal advice. So let's get to the program. Ever since I've been a labor and employment attorney, we've talked about the Bermuda Triangle related to leave issues. And typically that has been the family leaves, both federal and Oregon, ADA and workers' compensation. But now we really have a hexagon of leave laws, at least in Oregon and Washington as well. And that includes both Oregon sick leave and then the newest arrival, the Families First Coronavirus Response Act, which was signed into law on March 18th. Our focus today will be on COVID-19 related absences and how to manage them to ensure compliance with the intersection of all of these laws. Also, we will not be focusing much on the ADA aspects of these leaves, and we'll leave that to Bob and Haley to address next week. Rather, the focus here is going to be on the new FFCRA, or Families First Act for short, the traditional Family and Medical Leave Act, Oregon Family Leave Act, and Oregon Sick Leave laws. We will also be assuming that our HR professionals with us today have a very solid familiarity with most of these laws, and so we will not be discussing them in great depth and detail. Rather, we'll provide a high-level summary information and then move on to the thornier fact scenarios that you've probably been seeing in your workplace or will certainly come up in the near future. Our goal here today with this webinar is to help you understand how each law works separately, understand how each law relates to and potentially conflicts with the others, and be aware of when the laws overlap and when they don't. I'll now turn it over to Chris to get us started with a summary of the Families First Act.
Thank you, Kristin, and thank you everyone for joining us today. As most of you are likely aware of by now, the Families First Act created 2 new leaves that employers need to be thinking about. First, there's the emergency paid sick leave portion, which allows employees to take leave due to isolation orders, to care for themselves, or to care for others who are dealing with medical issues related to COVID-19, and also to care for their children during school closures. There's also the extended family medical leave portion, which is limited to the single use of allowing parents to stay home to care for their children during a school or childcare closure related to COVID-19. This law became effective a little over a month ago and will sunset at the end of the year. But one thing to note here is that the Department of Labor continues to release guidance since the law went into effect. So be sure to stay tuned for future developments as the Department of Labor continues to refine its interpretation of this new statute. A couple threshold questions that employers should be thinking about. First, are they covered? This law actually applies to most employers with fewer than 500 employees, which actually ends up covering about 75% of the workforce in the United States. I say most employers with fewer than 500 employees because there are some exemptions at play, most notably employers of most healthcare workers and first responders, as well as a hardship exemption for small businesses with less than 50 employees. One thing to note about the small business exemption is that it's only for employers who can show that they're complying with the leaves related to school and childcare closures. Just those two leaves would be an undue hardship, either financially or operationally. Second threshold question are which employees are covered? We'll go over some additional details here in a moment, but the general rule of thumb is that employees may use leave under Families First when the employer has work available for the employee, but the employee is unable to work those scheduled hours or the work that's available to them because of a qualifying reason. Importantly, the Department of Labor says that employees who are temporarily laid off or furloughed are not entitled to leave under the Families First Act. So with that, Kristin, can you give us a brief overview of emergency paid sick leave?
Pardon, I was muted. I'll get the hang of this before it's over. So thank you, Chris. First, we're going to talk about the emergency paid sick leave. Remember, these are two separate laws, even though that they might work in conjunction with each other, they are two separate laws. So with this new law, the key here is that the employees, all employees that are eligible are immediately eligible. There's no waiting period. And this includes your seasonal and temporary employees. Again, however, what Chris said is something that's going to carry through this entire program, which is employees who are laid off or on furlough are not eligible for the benefits. Employees who qualify for emergency paid sick leave are entitled to receive 2 weeks of paid protected leave. For full-time employees, and the Department of Labor defines full-time as any employee who works 40 hours or more, that's 2 weeks of paid leave capped at 80 hours. For part-time employees, generally speaking, there are specific nuanced rules here, but generally speaking, it's 2 weeks pay at their average hours worked during that 2-week period. As you'll see here in this slide, there are 6 qualifying reasons that we'll be discussing. We're going to go over them quickly so we can demonstrate how they work in just a moment. So Chris, do you want to get us kicked off with the first reason?
Sure, thank you. So the first emergency paid sick leave reason is that the employee is subject to a federal, state, or local quarantine isolation order. So this is pretty straightforward. In most cases, it's going to be a situation where the employee is directed by some sort of government official, such as the CDC or a regional health authority, to quarantine or self-isolate because they were exposed to COVID-19 or had COVID-19, something like that. There's some questions early on, though, when this law first was enacted as to whether or not shelter in place and stay-at-home orders would be a qualifying reason for this reason of emergency paid sick leave. The Department of Labor ultimately came out and said yes in some recent guidance that said that these orders may qualify an employee for emergency paid sick leave. But the key inquiry here is it's only to the extent the shelter in place or stay-at-home order is preventing the employee from performing available work. So this means that the employer is shut down to a shelter-in-place order and there's no telework available, there's no available work to perform, at least according to the Department of Labor, and therefore the employee does not qualify. One thing to note on this issue is that there are already some lawmakers around the country that are contesting the Department of Labor's interpretation on this issue, basically saying that employees should receive emergency paid sick leave due to business closures resulting from shelter-in-place orders. So what's going to happen from that, we don't know yet. It's ultimately going to be to the courts to decide if the Department of Labor's interpretation was too narrow.
Under reason number 2, the employee is taking leave because they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Important here is that there is a healthcare provider that's involved, and that healthcare provider has ordered the employee to self-quarantine because they either have COVID-19, they're suspected of having COVID-19, or they are a particularly vulnerable person due to perhaps their age or pre-existing health conditions. If an employee says, hey, I'm not feeling so well, we don't really know a lot about this virus, and so I'm going to go ahead and go home and just to be extra careful, this person does not qualify for reason number 2. That is because there must be an order by the healthcare provider that this person self-quarantines. So again, there can be no unilateral decision by the employee to stay home because of symptoms under reason number 2.
So reason number 3 is an employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. This is really a 2-part inquiry that employers need to be thinking about. First, does the employee report having some symptoms? So the DOL advises employers to basically look at the CDC's website to look if the employee is reporting one of the symptoms that CDC recognizes currently as a symptom of COVID-19, such as dry cough, shortness of breath, difficulty breathing, fever, chills, muscle pain, sore throat, loss of taste and smell, things of that. Of course, as scientists and physicians continue to learn more about this disease, the list of symptoms may expand. The second part of the inquiry, though, is the really fact-intensive issue that employers need to be thinking about. Seeking medical diagnosis means that the employee actually has to be taking affirmative steps to be seeking a diagnosis. A wait-and-see approach by the employee will not qualify them for emergency paid sick leave number 3. So for example, if an employee says, hey, I have a sore throat, I have muscle pain, I think I might have COVID-19, but I'm going to wait and see how I feel in a week from now, and then if I'm not feeling better, I'm going to go to the doctor. That week that they wait is not going to qualify them for emergency paid sick leave. On the other hand, if the employee tries to actually make an appointment and the doctor doesn't have time to see them until sometime next week, or they actually go try to get tested and they don't have the results yet and they have to wait a few days, that time spent will qualify them for emergency paid sick leave, but only to the extent they're not able to continue teleworking during that period. So we've covered the first 3 reasons for emergency paid sick leave, which are generally described as the employee's own medical issues related to COVID-19. And these first 3 reasons are paid at 100% of the employee's regular rate, subject to a daily cap of $511 or an aggregate amount of $5,110.
The next 2 qualifying reasons relate to an employee's care for others. And this is also paid up to 80 hours, but it's paid at 2/3 of the employee's regular rate of pay, with a daily cap of $200 and an aggregate cap of $2,000. Reason number 4 is for an employee caring for an individual who is subject to an isolation order or direction from a healthcare provider. Now, those of you who are familiar with OSHA and FMLA are going to say, hey, that seems interesting, individual. We haven't heard that term before, and we haven't. Typically, we think about caring for a family member, also under the Oregon Sick Leave Act. But the Families First Act has given a more expansive definition of who the employee can be caring for. Now, it can't just be any individual. There are some parameters. It must be a person with whom the employee has a personal relationship. And the Department of Labor's FAQs has said that can be an immediate family member, a roommate, or a similar person with whom the employee has a relationship that creates the expectation that the employee would care for that person. So again, this is much more expansive than the definition of FMLA family member, of a spouse, parent, or child, or Oregon's expanded definition of spouse, parent, child, grandparent, parents-in-law, domestic partner, and so forth. So again, just make sure you understand that distinction. With reason number 5, the employee is caring for a son or daughter if the school or childcare is closed due to COVID-19. The important part here is that childcare provider does not have to be a paid daycare or a public school. A child care provider can be, should be understood more broadly. It can be an unpaid family member or neighbor that regularly watches the employee's child, but due to COVID-19 is unable to do so. So the example that I've been using here is the grandparent who is typically watching the child, but because of COVID-19, the family has made the decision to isolate the grandchildren from the grandparents. So there's a disruption in childcare. Here, the DOL has also provided a broader definition to also include summer camps, after school camps. The idea here is to, again, just think of those of childcare as being more expansive, and it's really just the person or entity that is typically caring for the child. Last, with reason number 6, this is sort of a catch-all and perhaps a placeholder. So it's the employee's out for substantially similar conditions as specified by the Secretary of Health and Human Services. For those of you who've read the 90-something DOL FAQs, you'll know that the Department of Labor has noted that right now there are no similar conditions that have been identified. If that does change, then the Department of Labor will update their guidance and we will certainly notify you. So Chris, can you talk to us a little bit about expanded FMLA?
Sure, thank you, Kristin. Yeah, so as we referenced earlier, expanded FMLA, again, an employee can receive 12 weeks of expanded FMLA care to care for the children due to a school or child care closure. Very similar to reason, or almost exactly similar to emergency paid sick leave, reason number 5 that Kristin just discussed, with just a few differences. The main difference, of course, is that it is a lot longer. I think the rationale being that school closures are, foreseen to last much longer than an individual's illness dealing with COVID-19. So we say up to 12 weeks of total leave. It's because the leave is subject to FMLA, traditional FMLA that the employee has already taken in the leave year. So for example, if an employee in their leave year already took 6 weeks to recover from a knee surgery, that employee is only going to have a maximum of 6 weeks of expanded FMLA available to them due to a school or child care closure. A couple of important parts here are that the first 10 days of the expanded FMLA are unpaid, but the employee can use emergency paid sick leave, again, reason number 5, to cover their pay during that unpaid period, or they can tap into their employer provided leave, or they can decide that they don't want to use any leave whatsoever. The important thing here is that during this unpaid period, it's the employee's choice about how they're going to get paid, what sort of leave banks that they want to use. And just like emergency paid sick leave, expanded FMLA is paid at 2/3 of the employee's regular rate, capped at $200 a day, $10,000 aggregate total. A couple things that we should note, that there's obvious differences between expanded FMLA and traditional FMLA. First, FMLA applies to employers, of course, with 50 or more employers within a 75-mile radius, whereas expanded FMLA does not have that geographic boundary threshold. It's just whether or not the employer has fewer than 500 employees. The second difference is that traditional FMLA applies to employees who have been employed at least a year and worked 1,250 hours in the immediately preceding 12 months, whereas expanded FMLA applies to all employees who have been employed for at least 30 calendar days. Now, one thing to note here that's of interest to employers who have furloughed employees and are starting to think about bringing them back at some point, the Department of Labor says that employees who were laid off on or after March 1st but are subsequently rehired, they're also immediately eligible to take expanded FMLA if they worked for their employer at least 30 of the prior 60 calendar days prior to their layoff. So with that, Kristin, can you tell us about Oregon's protections?
Thank you, Chris. Just briefly, I want to note Oregon also has some COVID-19 protections as well. As many of you know, BOLI has amended the OFLA regulations, and now sick child leave has been expanded to include school and child care closure due to public emergencies such as COVID-19. Otherwise, all of the OFLA rules that we know so well still apply. So this is only, employees are only eligible if they work for an employer with 25 employees or more. And if that employee works 180 days, has 180 days of employment and works at least an average of 25 hours per week. Another interesting thing to note here is that the emergency rule is effective from March 18th, 2020 to September 13th, 2020. As we are starting to now grasp, the pandemic will probably not be completely over by September, so we would fully expect that this to be, end date to be extended. We'll certainly keep you informed. Secondly, Oregon sick leave has not been changed. However, BOLI has provided some very helpful guidance. First, it is expressly stated that school and child closure or disruption due to COVID-19 falls squarely within the qualifying reasons of absences due to order by public office declaring health emergency. We already figured this was the case, but it was helpful to have BOLI confirm that. The second one is that employees who are uncomfortable going to work due to the virus are entitled to use their paid sick leave to cover absences. The second one wasn't necessarily intuitive, so it's good that we have the guidance from BOLI, and certainly employers need to conform their practices to that. Now it is time to get into some hypotheticals to put all of this together. And while I love having so much time with my family, that's downstairs, I really miss my work family. So we're going to visit some of our favorite work family shows while we try to talk about some of these issues. And remember what it's like to have outside interaction and fellowship with our workmates. So Chris, why don't you kick it off from here?
Sure, and yeah, thank you. So let's go to our favorite cast of characters from Scranton, Pennsylvania. But for the moment, we'll pretend that Scranton's in Oregon. So Jim and Pam's 10-year-old daughter, Cecilia, can't go to school due to COVID-19. Jim notifies his boss, Michael Scott, that he can't work because he needs to take care of Cecilia. Although Jim usually works at the office, Michael set him up to work remotely during the COVID-19 pandemic. Pam attends art school remotely full-time. So let's break this down. First question, does Jim qualify for Oregon sick leave and Oregon family leave? Well, the answer is yes, pretty straightforward. As Kristen just explained, OFLA and Oregon sick leave both allow Jim to take leave due to emergency school closures, which certainly seems to be the case here. Pretty easy. What about the Families First Act? I think it depends, and there's a few things we need to look at here. First, the Department of Labor tells us that if another parent is home and available to watch Cecilia, then Jim doesn't qualify. But here, Pam is not available to work, is not available to watch Cecilia due to her art school attendance. So that wouldn't disqualify Jim from using emergency paid sick leave or expanded FMLA. On the other hand, if we knew that Pam's school schedule was such that she and Jim were not going to school and working on the same day, then Jim might not qualify on the days where Pam is not attending school. The other thing we need to look at is the fact that Jim's been set up for telecommuting. The Department of Labor tells us that to the extent Jim is still able to telework while watching Cecilia, he won't qualify. But just because Jim could telework, that doesn't mean he can do so effectively and productively while watching Cecilia. I think the takeaway from this is that if Jim makes the representation to Michael that he is unable to care for Cecilia while working, then Michael should probably give him the benefit of the doubt and allow him to take leave under emergency paid sick leave reason number 5 and for expanded FMLA. Let's look at a couple curveballs here. What happens if Jim demands intermittent leave? Can he do that? Well, no, he can't unilaterally demand intermittent leave, but he can have intermittent leave so long as Michael agrees to it. Jim and Michael can come to whatever flexible agreement that they think is appropriate under the facts and circumstances, such that Jim could maybe work some mornings and then take off in the afternoon to watch Cecilia, or maybe he'll work Monday, Wednesday, Friday and take off Tuesday, Thursday, whatever they can agree to. Michael would be advised, though, that if he does agree to an intermittent schedule, he should probably document the agreed upon schedule so he can use it as a reference point later on if there's ever a dispute. Second curveball, what if Cecilia's school is out for summer as of June 1st, but Cecilia's July summer camp gets canceled? The Department of Labor just released some guidance on this issue actually last week and was referenced by Kristin earlier, confirming that Jim does not qualify for childcare leave under Families First as of June 1, since the school will no longer be closed due to COVID-19. However, the Department of Labor guidance also tells us that a child's place of care is defined broadly to include daycares, summer camps, and things like that. So while Jim might not be eligible for Families First leave in June, he may requalify for leave again in July to care for Cecilia due to the summer camp closure. And with that, let's go visit our newest cast of characters from Oklahoma and Florida. Kristin?
All right, so this is definitely one of the more bizarre workplace families. So let's see what's going on here. Eric, who works 50 hours per week, has a sore throat and is immediately sent home by his boss, Joe Exotic. Eric attempts to make an appointment with Dr. Baskin, but she says, give it a week. Still not feeling better a week later, Dr. Baskin feeds him to the tigers? No. Orders a COVID-19 test. Comes up negative. Eric misses 2 weeks of work. All right, I don't know if any of you guys have seen Tiger King, but it's a wild ride, and I will just warn you now that if you start watching it, you will not be able to stop. So we're going to go ahead and go down the same analysis that Chris just used. Does Oregon sick leave apply when Eric is sent home by the employer? And the answer here is yes. Since he's been sent home because of his symptoms, he is eligible to use his accrued paid sick leave. And this is regardless if he seeks medical attention or not. Just the fact that he's been sent home because of his symptoms, that is sufficient. The next question is OFLA or FMLA implicated here? Now, first off, because this is a relatively small employer, it's probably not a covered employer under Oregon or federal law, but let's put that aside and just take a look at the symptoms. Just having symptoms of a sore throat is probably not sufficient to rise to the level of a serious health condition, so no. But remember that if it's a common cold or flu or just a temporary condition caused by some bug, that's generally not going to be a qualifying event under either FMLA or OFLA. However, if the symptoms develop into something more severe, like pneumonia or something else, that might rise to a serious health condition and it might be covered. The next question we ask ourselves is, what about Families First Act? Here, the emergency paid leave in particular. And the answer is it depends. Assuming Eric, who feeds cats and cares for tigers, is not able to do that through teleworking, which that's not the case. Just being sent home because of his symptoms would actually not qualify him for emergency paid sick leave, even if it is at the employer's request. However, once Eric seeks medical attention, then the answer becomes yes, under reason number 3. And so remember, the 2 factors there are he's experiencing symptoms of COVID-19 and he's seeking confirmation from a healthcare provider. So as long as the employee is seeking a medical diagnosis, it's irrelevant if the test is positive or negative, or even if there's no test at all. Actually, there doesn't even have to be a diagnosis made. As long as the employee is seeking medical attention to determine what is causing the illness, then reason number 3 under the emergency paid sick leave will apply. Quick question, how much should Eric be paid? This is an employee who works 50 hours every week. So because the leave is for his own illness, he's entitled to be paid for 2 weeks capped at 80 hours. And this again is at 100% of his regular rate of pay. The Department of Labor says that employees will be paid for the hours they typically are scheduled to work during that week. So here, since Eric works 50 hours a week, he will be paid 50 hours for week 1. And then in week 2, he'll be paid the remaining 30 hours for a total of 80 hours. Then after week 2, after those 30 hours have been provided, protected, and paid, his rights under the emergency paid sick leave will be exhausted. Now, Eric can still use his Oregon sick leave or potentially PTO to cover the rest of week 2's absences. So let's add one more dimension to this fact scenario. Here's my curveball. What if the test, let's see, what happens if Eric tests positive for COVID-19 and believes he's contracted it at work? If this is the case, then Eric may and should file a workers' comp claim. In fact, the employer is required to submit a Form 801 to the workers' comp provider, notifying them that there's been a workplace or potential workplace illness or injury. In that situation, Oregon sick leave will not apply because it does not run concurrently with workers' comp. The same would be true for emergency paid sick leave. So any time loss that is suffered by Eric that is going to be covered by workers' compensation would not also be covered by the Families First Act. All right, Chris, back to you.
All right, thank you, Kristin. Let's go to Pawnee and visit our friend Leslie and her beloved uncle. But again, let's pretend Pawnee, Indiana is actually Pawnee, Oregon. So Leslie Knope is an essential worker who cannot perform her job duties remotely. Leslie learns that her uncle is diagnosed with COVID-19 and is ordered to self-quarantine. Leslie Knope, who lives alone, Uncle Knope, who lives alone, is experiencing moderate symptoms, and Leslie feels the need to care for her uncle. Leslie calls Pawnee's HR to inquire about leaves available to her. So first question again, does Leslie Knope qualify for Oregon sick leave or Oregon family leave? The answer is no, because uncles and aunts, for that matter, are not included in the definition of family members under either law. But what about Families First Act? Well, I think we can quickly dispense with expanded FMLA because there's no school or childcare closure here. But what about emergency paid sick leave? The answer is maybe. I think we need to know a little bit more information and run through the facts here. So as Kristin described earlier, under emergency paid sick leave number 4, an employee can take EPSL to care for an individual if that individual is quarantined or isolated if 3 things exist. First, the individual is unable to care for themselves. The individual depends on the employee for care, and caring for the individual prevents the employee from working. Again, the Department of Labor says this individual can be an immediate family member, someone who regularly resides in the employee's home, or someone the employee has a relationship with, which creates the expectation the employee would care for the person. So it's a much more expansive definition than OFLA or FMLA, but it's also pretty squishy and vague in some respects. The Department of Labor says that this person definitely can't be a stranger, so it's someone more than a stranger to you, but you still have to have some relationship with them. So turning to the facts, Leslie may qualify. She doesn't live with her uncle, and he's not an immediate family member, but he is her beloved uncle, so their relationship is probably close enough. But I think what we'd also need to know is if her uncle's symptoms are bad enough, we only know that they're moderate, that he can't care for himself, or whether there's someone who already lives with Uncle Knope that would be expected to and is able to care for him. I think the bottom line here is that if Leslie is Uncle Knope's only relative in town, she'll probably qualify. Let's add a curveball here. What happens if, and let's just assume Leslie does qualify for emergency paid sick leave. What happens if she wants to use intermittent sick leave to care for her uncle? Can she do that? The answer is no, even if the employer wants to let her use intermittent leave. Rationale here is that the Department of Labor says employees who work at a physical job site and don't telework cannot use intermittent leave to care for their own medical issues or to care for another individual who has medical issues related to COVID-19. Again, the thinking here is that an employee who's around COVID-19 or is exposed to COVID-19 shouldn't be coming to and from the workplace and risk infecting their coworkers and everyone else that they're around. So with that, I think we'll go ahead and open it up for any follow-up questions that folks might have. And it looks like we already have a couple here. One participant asks, does OFLA for childcare closure run concurrently with expanded FMLA for childcare closure? Kristin, do you want to handle that or should I?
I can certainly answer that one. So the answer here is yes, those 2 things will run concurrently. The second question, and I'll prep this one for you, Chris. Are small employers under 10 employees subject to the emergency paid leave and expanded FMLA leave?
Sure, thank you. And I think, yeah, the answer is yes. The default answer is yes. The law says that small business exemption may apply to employers with fewer than 50 employees, but the employer with fewer than 50 employees will have to show some documentation or be able to document that there's a financial hardship. And then the employer, currently the Department of Labor says that the employer can make the decision on their own whether they do or do not meet the requirements of the exemption. And there's a few different reasons for which small employers can qualify for the exemption. And someone high up in the company, such as a financial officer or CEO or someone who has sufficient purview or overview of the organization's financials and operational structure, can determine that complying with the emergency paid sick leave due to school closures and or the expanded FMLA would be too big of a burden on the organization. So long story short, all employers under 500 have to comply with this. Employers with fewer than 50 employees can opt out if they can make a determination that it would be too big of a hardship on them.
Chris, we have one more question here, and that is, do the benefits paid by employers under COVID guidelines, and here we're assuming that we'll talk about the Families First Act, come off the employer's payroll tax liability? The answer here is yes. Any benefits that you are paying, if you're a private employer, public sector employers don't get the tax break, but if you are a private employer subject to Families First, and any of those benefits that are paid to employees will be, you will be given tax forgiveness for those.
Okay, it looks like we got another question here. Has BOLI given direction on how they will investigate for COVID infection at work? Well, I think what employers need to be thinking about right now that are reopening primarily is actually OSHA. Oregon OSHA has already started fielding thousands of complaints from employees and just random third parties saying, hey, we don't think that this organization is complying with Governor Brown's orders. And so far, Oregon OSHA has basically given employers the opportunity to say, and in most cases, present evidence showing, no, actually, this is what we've done. This is what we're doing to comply. And if the employer doesn't respond, then they may receive follow-up from Oregon OSHA and may investigate to make sure that they're actually complying and making sure that the workplace is safe. In terms of what BOLI might do, you know, again, I think that they're going to be more concerned with whether or not employers are not discriminating, not retaliating against, not interfering with employees' leave rights. And I haven't seen anything personally yet on that front, but that's not to say that we won't see something in the future.
Chris, I can take the next question.
Sure.
One of our attendees asked, do we need to get employee certification of some sort if the employee is claiming that their spouse partner cannot care for their kids at home, so they need to be off to care for them? Can we ask such questions? We were very surprised to see the DOL regulations on what employers actually can ask for, and it is very, very limited. So for purposes of the documentation that employers are able to get for school closure, it's the name of the child, the age of the child, the school or the care provider, and a certification from the employee that says that there is no other suitable person to care for the child, and that is it. So it is fairly limited. Now, just a week ago, the DOL came out with another FAQ related to a belated request for caring for a child. So this is a situation where a person has been teleworking since late March, and then all of a sudden comes up and says, I need to take time off for school closure. Teleworking just isn't working. And in that situation, the DOL said that the employer, while treading lightly, can ask for some sort of certification about the changes in circumstances that has led to the employee now needing childcare, belated request for childcare. But if the reason is plausible at all, the employer should give the leave, and that leave is protected.
Looks like we have one more question here about if an employee takes a 12-week leave under the expanded FMLA, does this trigger COBRA? You know, to be completely honest, I don't think so. I'm not entirely sure, but I'd let Kristin, it looks like Kristin's agreeing with me here. Yeah, I'm not a huge benefits guru yet, but yeah, no is the answer. Should employers give employees the option of FFCRA leave or layoff? Can employers require employees to take FFCRA leave? Well, I think the answer here is that if the employee requests FFCRA leave, they should not be laid off, and they should be given the leave. If on the other hand, the employer pre-request has decided, hey, we need to lay this person off because of operational financial difficulties, then, you know, I guess the potential, not upside, but I guess saving grace for the employees that right now the uninsurance benefits are so robust that, you know, they might actually volunteer. They would actually prefer to be laid off. So I guess ultimately I would just say that employers should not be making layoff determinations if an employee is coming and asking about FFCRA leave.
Okay, we have time for one more question. The question is, how do we handle employees with unfounded feelings of being uncomfortable as a reason to not come to work? Well, this is a certainly loaded question. We've been getting lots of calls on it, so it's pretty pervasive, I would imagine. And so really, I think the first thing here is it's not the employer's place to determine whether it's unfounded or founded. What BOLI has said is that if an employee calls and reports that they are uncomfortable to work and due to virus exposure, that time is protected by Oregon sick leave. So if that employee has any leave available to them, they are entitled to use it under Oregon law. Otherwise, it's not going to qualify under any of the other leaves that we've been talking about today. So I'm going to go ahead and wrap this up. We really thank you all for your questions. They're excellent. I see there's still a lot more waiting, and hopefully we can get to them offline. We hope that we were able to provide some help and guidance with these difficult times and ever-changing waters. We certainly sympathize with what you're facing. Please reach out to me or Chris or the Tonkon Torp attorney that you usually work with any additional questions. And if you don't already have a relationship with Tonkon Torp, we invite you to contact one of us, and we're happy to set up a call and time to talk to you. Again, thank you for attending. Be well, be healthy, take care of yourself.
Thank you. Goodbye, everyone.